Yes.
Your Honour, as in the opening, I will address you first on the claimant's failure to procure completion of the project by 31 March 2015. Mr. Francis will then address you on the other two defaults.
Thank you.
Your Honour, there's no dispute that the claimant did not procure completion of the project by 31 March 2015. Accordingly, to show that the defendant was not entitled to cancel and accelerate the loan, the claimant needs to demonstrate one of the following: impossibility, bad faith, waiver, abuse of rights, or that its failure to procure the completion by the specified date was not an event of default within the scope of Article 23.2. Your Honour, it's the defendant's case that the claimant is unable to demonstrate any of the above. Let me deal first with impossibility. The primary argument here relies on Article 129 of the Civil Code. The claimant's case is that the obligation was, as a matter of fact, impossible ab initio. The claimant has to establish that it was impossible. That, Your Honour, is a high bar and one that cannot be reached based on the evidence. Reliance is placed on the Hill International briefing paper from August 2014. Now, we'll obviously deal with the evidence in more detail in the written closing, but let me make a few points now. The July 2014 programme referred to in that report is not in evidence. The claimant has not produced it. Hill International's estimate of completion by 1st August 2015 was based on a scenario where, and I quote, "the current status is allowed to continue as is." And you can find that, Your Honour, in volume 9 of the bundle, tab 129, page 1787. The paper refers to under-resourcing by the contractor, but it is surely possible that more resources could have been added. A similar point arises in relation to the E.C. Harris report that was produced in October 2014. It is an assessment based on an existing state of affairs. That does not mean that the issues raised, such as the level of resources deployed by the contractor, could not have been addressed. Now, as to the effect of Article 129, the claimant argues that it renders the relevant obligation void ab initio. The claimant relies on the official commentary to Article 472 in support of its interpretation of Article 129, but it's not clear why the former is said to be relevant to the latter. There is no reference to Article 129 in the relevant commentary. No authority has been provided to support the application of that commentary to Article 129 or to otherwise support the claimant's interpretation of Article 129. Article 129 expressly refers to and deals with the subject matter of the contract, not individual obligations within a contract. The subject matter of the contract in this case is the loaning of money for the purpose of building a hotel and the repayment of that money. There is and can be no suggestion that that subject matter was impossible. The alternative argument on impossibility is based on Article 472 of the Civil Code. Now, here the claimant has to show impossibility arising after the date of the restatement due to an extraneous cause in which he played no part. Again, the evidence does not show that, Your Honour. The claimant relies solely on the restriction on Intermass's licence. In his evidence yesterday, the claimant said that when he went to trackies about this, they said that they didn't know what the restriction was. The claimant said that he had then learned from the Dubai Economic Department that it had been placed there by the Dubai municipality, find that, Your Honour, on the transcript at day 2, page 30, lines 18 to 22. Now, the letter we have in the bundle from Dubai Municipality from early May 2015 indicates that the restriction only applied to new projects. Again, Your Honour, you can find that in volume 13 of the bundle at tabs 231 and 232. If there was an issue, it appears to have been limited to the seafood restaurant. There is no clear evidence that it prevented Intermas from performing other works. Now, as Mr. Thomas QC said in his opening, and I quote, "It's not an entirely clear story." It's certainly not a story that demonstrates impossibility under Article 472. Now, because there's no evidence of impossibility, you don't even get to the issue of an extraneous cause in which the claimant played no part. But even if you did, the evidence on that is also insufficient. For example, there is no evidence of any steps that the claimant could or could not, did or did not take in respect of resolving this issue. Turning to bad faith. This is primarily based on the allegation that NBAD knew, as at the date of the restatement agreement, that it was impossible to complete by 31 March 2015. We went through the relevant evidence on that in opening. The short point was and is that there is no evidence that NBAD knew, as at the date of the restatement, that completion by the 31st of March 2015 was impossible. In opening, I showed you the email under cover of which Hill International sent its briefing paper to the claimant. You may recall that the email contemplated that the paper might not be circulated more widely. Specifically, there was a reference to the need for the claimant's approval before that would happen. And you can find that in volume 9 of the bundle, tab 129, page 1782. Evidence yesterday, the claimant confirmed that he had not given that approval. You can find that on the transcript at day 2, page 19, lines 22 to 24. As to the allegation that NBAD must have known that progress was impossible based on the utilisation requests it received in the months prior to the restatement, in her witness statement, Ms. Shocker said that NBAD did not use these to monitor progress or the estimated completion date. And you can find that, Your Honour, in volume 2, tab 21, page 435. In her evidence yesterday, she pointed out that there was often a time lag between work being done on site, a payment certificate being issued in respect of that work, and that payment certificate being sent to the bank. In short, whatever payment she was processing did not reflect the existing situation on site. And the transcript reference, Your Honour, is day 2, page 120, line 24 to page 121, line 11. Now, we can cover the other evidence on this in closing, but we would invite you to look at the utilisation requests and draw your own conclusion about their usefulness as a measure of progress or the estimated completion date, let alone one that would lead NBAD to inevitably conclude that completion by 31 March 2015 was impossible. There are only 4 potentially relevant utilisation requests, and they're in the bundle in volume 9 at tabs 128, 130 and 135, and in bundle 10 at tab 147. Now, the claimant also argues that NBAD was not motivated to terminate based on a failure to meet the 31 March completion date, but rather by the prospect of Intermas being terminated. And this was a point raised by Mr. Thomas QC in his opening. Whilst it's clear that NBAD was rightly concerned about termination of the existing contractor, nothing in the evidence you have heard in the last 2 days bears out the allegation made by on the issue of waiver. There is no evidence of an unequivocal representation or affirmation that would or could override the express no waiver provision in Article 30 of the Restatement Agreement. So you don't need to look beyond that article on the issue of waiver. But even if you did, under Article 135, the default position is that silence does not constitute acceptance. So if the claimant is to succeed, it needs to prove the exception rather than the rule. There needs to be silence in the face of a need. In any event, there was no silence. The claimant relies on NBAD continuing to allow drawdowns under the loan until 9 March 2015. First, it's important to note that the 2 drawdowns allowed on 9 March 2015 were the only ones in that year. The evidence relating to why those drawdowns were allowed is in the bundle Volume 12, tab 194, page 2560. Second, in his evidence yesterday, the claimant confirmed that the issue of halting drawdowns had been raised, both before and during the 23 February 2015 meeting. So that's at day 2, page 44, lines 16 to 17. Reliance on the drawdowns also ignores the repeating representations made by the claimant in each utilisation request, which include the representation at Article 20.2 of the Restatement Agreement. All of the claimant's obligations remain legal, valid and binding. And Your Honour, the reference for that provision is Volume 6, tab 45, at page 1102. Now you may recall that we looked at that in opening, albeit in the context of the claimant's arguments on impossibility. It's also said that NBAD did not sufficiently express to the claimant that it required completion by 31 March 2015. Your Honour, the requirement could not have been clearer. It is there in black and white in the Restatement Agreement. The best that the claimant appears to be able to do on this is that there was no letter in January 2015. In his evidence yesterday, Mr. Socken confirmed that there had been a lot of discussion with the claimant about where the project stood, the delays, the effect of those delays on the completion date, and how the claimant would be moving the project forward. And the reference for that, Your Honour, is day 2, page 153, lines 5 to 14. A meeting followed on 23rd of February 2015 with Mr. Abdul Haq, NBAD's Group General Counsel, in attendance, at which concerns were raised, including the potential termination of Intermas, the existing delays, the halting of drawdowns, and the need for a clear strategy going forward. And the evidence relating to that meeting is in Volume 12, tab 194, at page 2560. This was followed by NBAD's letter dated 18th of March in the bundle at Volume 12, tab 207. Two further letters followed on the 24th of March and the 30th of April 2015, before NBAD issued the notice of demand on the 21st of May 2015. And the bundle references there are Volume 12, tabs 212 and 227, and Volume 13, tab 251. Now, all of these letters expressly reserved all of NBAD's rights. On the interpretation of Article 23.2, we covered this in opening. In summary, NBAD's position is that if an obligation falling within the scope of that article is not capable of remedy, there is no requirement for a notice to be given. In opening, we pointed out the consequences that would flow from the claimant's interpretation of Article 23.2, in particular, that it would result in an obviously important provision having no express contractual effect. Now, on the importance of the provision, Mr. Socken explained yesterday that the 31 December 2015 repayment date that is found in the restatement agreement was based on the completion date. There was a link between completion and repayment. If there was a requirement for a written notice, each of NBAD's letters dated 18 March and 30th of April satisfy that requirement. Both deal with the claimant's failure to procure completion by the specified date as an event of default. Both fall more than 15 days before the notice of demand, which was issued on 21 May 2015. Any reliance placed on the absence of an express request for remedy in those letters is, Your Honour, disingenuous. This was a serious breach of an important provision, and NBAD was reserving its rights in full, including its right to enforce its security. In his closing, Your Honour, Mr. Thomas QC referred you to paragraph 61B3 of the defendant's amended defence, referred and stated that there you could find an admission that the breach of the completion date requirement was not capable of remedy. And all I wanted to do briefly, Your Honour, is just draw your attention to the fact that in the same sub-paragraph, in fact, the very next sentence, you find the defendant's case on the true construction of the facility agreement, which reads as follows. On the true construction of the facility agreement...
You're just to get me to the right place here.
Apologies.
The amended defence at...
I'm in Bundle 1,
yeah.
tab 8, page 150.
150, okay. Yeah. And we're looking at what?
It's Roman numeral 3, Your Honour, so second sub-paragraph down on that page. Mr. Thomas drew your attention to the first sentence, and I simply wanted to draw your attention to the sentence that immediately follows that, where the defendant's argument on the true construction of the facility agreement is set out. Finally, Your Honour, abuse of rights.
Yeah.
Now, the claimant relies only on Article 106C, which provides that the exercise of a right shall be unlawful in the interests, if the interests desired are disproportionate to the harm that will be suffered by others. The official commentary on this provision refers to the following. The exercise of a right for the purpose of achieving an interest that is of little significance and disproportionate to the harm that would thereby be caused to another. The criterion in such a case is objective and material, but it often happens that there is indicative evidence of the intention of causing harm to another. Now, Your Honour, this is not a case involving the exercise of a right for the purpose of achieving an interest of little significance. There can be no doubt that in exercising its rights, the bank was protecting significant and legitimate interests. This was a large facility and the bank was rightly concerned about completion and repayment. As to the consequences for the borrower and the project, they might be unfortunate, but they are the commercial risks that the claimant accepted when he entered into the restatement. It is, Your Honour, the same in any similar loan transaction. The financial and other consequences of default can be significant. However, to enable a borrower to escape those contractually agreed consequences on that basis would render a bank's rights meaningless. The borrower could simply claim financial hardship to escape its obligations. That, Your Honour, that just cannot be right. Your Honour, Mr. Francis will now address you on the 2 remaining defaults.
Thank you very much.
I will address you first on the conditions subsequent defaults, beginning with the amended construction contract and the construction contract assignment. Now, on day 1 of this hearing, Mr. Thomas said in his opening submissions, he said, open quotes, there wasn't actually an amended contract, so the claimant can't be in breach by not supplying something that just didn't happen. And obviously, there couldn't have been an assignment of that either. So, for the note, day 1, page 76, beginning from lines 24 to 25, and then over the page. That appeared to be the claimant's primary argument on opening. It appears by closing, the claimant's argument has shifted somewhat to an argument based on amendment number 2 to the construction contract. If I understand Mr. Thomas's closing submissions correctly, it appears that the claimant now maintains that amendment number 2 satisfies the obligation to produce an amended construction contract within the meaning of the conditions subsequent obligation. Now, I'll come on to that later, but I'd just like to say that the defendant's position on this is based on the express wording of clause 5.3. It says the borrower shall deliver each of the documents and other evidence listed in Schedule 2, conditions subsequent to the lender, in form and substance satisfactory to the lender, and then on or before the date, and the date was 30 September 2014. And then B, if any document is not delivered by the time limit required, that non-delivery will constitute an event of default and no grace period shall apply. Paraphrasing. Now, our case is the conditions subsequent obligations mean what they say. The obligations are not optional, they are not conditional on the required documents coming into existence, and they do not give the defendant any discretion to finally determine the form and substance of the satisfactory documents. I'll ask you to pick up volume number 9, please, Your Honour. And turn to tab 133. Now, this is an email from Ms. Shocker to Mr. Blow, dated 14 September 2014. And you see, this is before the restatement is signed. You see, Ms. Shocker is chasing Mr. Blow for the amended contract with Intermass. You see that first line, the following is urgently required for the perfection of the documentation. Item number 1. Target date for finalisation / perfection of the amended contract with Intermass. At the bottom of this email, you see Ms. Shocker is referring to a copy of the condition precedents and condition subsequent checklist, which will be provided once finalised by Clifford Chance. If we turn over the tab...
Where are you reading then? At the bottom
at the bottom of page 1825.
Oh, actually, yeah.
If we turn over to the next tab, that is the checklist that was provided by Clifford Chance, and it's referred to in Mr. Al-Mahari's first witness statement, so it's quite clear that the claimant was provided with a copy of this document before the document production phase of this litigation. And if we turn the pages over to 1833, see, it's quite clear from item number 4. It says, a copy of the construction contract as amended, duly executed by all parties thereto, certified as true, complete and accurate by a duly authorised officer of the borrower. Then in the next column you have the deadline, then you have the responsible party, the borrower, so the claimant, and comments current status column, the borrower to provide. So it's clear that the defendant is expecting the claimant to provide an amended construction contract, and by receipt of this checklist, we must assume that the claimant was also aware at this stage that the defendant was expecting an amended copy of the construction contract. It would be meaningless to have this requirement, to have the date of provision of 30 September 2014 if it had already been satisfied by the 2010 construction contract, as one argument. It's clear that after this date, amendment number 1 was provided by the claimant to the defendant. Of course, that was not signed by Intermas. Amendment number 2 was provided, and it was signed by both the claimant and Intermas. However, the defendant had reason to believe that this amendment number 2 was not a final, agreed, amended version of the construction contract. If I can ask you to pick up volume 10, please. Turn to tab 163. Page 2258. Now, this is a letter from Hill International to the claimant, dated 2nd of October 2014, in response to the claimant's query, you'll see in the first line, requesting advice on whether to sign contract amendment number 2 or otherwise. So it hasn't been signed up to 2nd of October 2014, so it's already late. Then the last bullet point, Hill International are telling the claimant, the amount defined in contract amendment number 2 still remains subject to variation by either omission and addition.
I'm very sorry, where are you reading?
I'm sorry, Your Honour. The last bullet point
Of
page 2258.
2258.
Sorry, you should have a letter from Hill International.
No, I'm sorry, I'm in the wrong page altogether. 2158 I was on. Okay.
So the last bullet point on that letter to the claimant says, the amount defined in contract amendment number 2 still remains subject to variation by either omission and addition, and in signing the same, DAS are not committed to paying the full amount to Intermas in the event that the aggregate of all such variations results in a lesser contract value. And then they finish, as stated, we can recommend signing said document as soon as practicable. And if you go to the front of
I've never seen this letter. It's a very strange letter, isn't it?
well, we say it's
And sign the amendment, but on the basis that it isn't finalised. Is that right? Or does it simply mean you can sign this, but it remains subject to variation, which of course it does.
so
What the DAS are saying, they're not committed to paying the full amount. What, as provided in the amendment?
Yes.
I just don't quite know what it means.
it's saying, at least our interpretation of this letter is, you can sign this contract, don't worry about it, we're still in ongoing negotiations over variations. Therefore, the amount that you are signing up to in this amendment number 2 is not the final agreed sum of the contract.
That's a strange way of contracting, isn't it?
Absolutely, Your Honour.
Yeah. Okay. So anyway, as I say, I haven't seen this letter before, have I? I don't think so. Right. Yeah.
And if I can just, while we're here, if you just turn to page 2260, you see the much earlier letter from Intermas,
Yeah.
dated 31 August 2014, and it's addressed to the claimant, and you see the middle paragraph. There is Intermas's comment on signing amendment number 2. They say, "We have signed the amendment on the understanding from Hill International that the bank will not continue to finance the project without this amendment."
Well, the inference being they're signing it solely for that purpose, without intending to be bound by it.
Precisely, Your Honour.
Yeah.
And both of these letters were provided to the defendant, which is evident from the front page of this tab, so page 2156, if you turn to the front of this tab.
2156, yeah.
This is the email from Ms Shocker to E.C. Harris, Mr Jonathan Hall.
So these are all exhibits to some email, are they?
These are all attached to Ms Shocker's email of 16 November 2014. This is a snapshot of what the defendant understands as to the claimant's ongoing negotiations with Intermas.
Okay. Yes.
I think actually the attachments also include the unsigned version of amendment number 1.
Well, he attaches 2 amendments, so there must be
Yes, there is, and that
the unsigned one and the signed one.
precisely. And you can
Yeah.
see that on page 2251.
2251.
Yes, this is the draft or the unsigned version, or signed only
Oh, I
by
see. Okay.
claimants.
Right, sorry, I've interrupted too much, yeah?
I'm sorry, if you look at page 2251,
Yeah.
same tab, this is amendment to contract number 1. So this is the first amendment
Right.
that was not signed by Intermas.
Right,
And if you turn over the page to 2253,
yeah,
you'll see this is the version that's only signed
right.
by the claimant and signed by Mr Blow. I believe that's Mr Blow's signature. Of course, there were other unsigned or incomplete amendments to the construction contract. And if I could take you briefly to those. If you could pick up bundle 15. Go to tab 298.
You see 15?
Yes, Your Honour.
Sorry, I think I've managed to spill everything. I'm just mislaid 15 for a moment. Can't see it anywhere. Very odd. Yeah, maybe this is it. Yep, sorry. Yep. Page or divider.
Tab 298.
Thank you. Yeah.
See, this is a letter from the claimant to Intermas dated 19 November 2014, signed by Mr Blow, attaching 3 copies of amendment to contract number 3 for your further action, asking Intermas to kindly append your signature and return 2 copies to us for our records.
Now, we're way past September. So what's the significance of this?
Well, these documents were provided to the defendant, and we say that is evidence that
Yeah, but if they were taking stock of where they were in regard to conditions subsequent, as at the 30th of September, they wouldn't have seen this, would they?
no, 30th September 2014 was the deadline for
Right.
provision of all the documents to satisfy the conditions subsequent.
So the fact that there was a later proposed amendment is neither here nor there, is it? Well, if it is, you'll have to explain it to me.
Well, it shows that the amended construction contract had not been finalised up to this date,
What it all shows is a further amendment.
but it wasn't signed, Your Honour.
Right, sorry, a further proposed amendment. I mean, supposing there was an amendment in 2015 proposed, so what?
Well, it's to explain why there are no documents, emails or letters chasing for satisfaction of the amended construction contract, condition subsequent.
Oh, that's a different point. Okay. You're not showing this to me to show that this was an unfinalised amendment at the time when condition subsequent needed to be satisfied. You're merely saying that even if they had received appropriate signed amendments 1 and 2 by the 30th of September, nonetheless the bank were under the impression, as a result of documents such as these, that further amendments were in train, and therefore they decided to wait and see what happened. Is that the point?
Yes, Your Honour, that's one part of it. The second part of it is it is also evidence that amendment number 2 is not an amended construction contract in form and substance satisfactory to the defendant.
Well, that's the bit I'm not getting. I mean, assuming they signed it, and it was in existence on the 30th of September, why does it follow from the fact that about 2 months later another amendment was in the arena, that the earlier amendment didn't, together with the original contract, constitute the amended contract?
But it's for the bank to decide whether or not the document that's submitted is in a form and substance satisfactory to the bank.
Follow that. And why was the second amendment unsatisfactory? I don't think there's any evidence about it. It's a question of opinion, is it? I've forgotten now. Sorry, you have to remind me.
Well, I'll bring you on to the contemporaneous evidence which shows that the defendant continued to chase for unsatisfied condition subsequent, which we say incorporates chasing for the amended construction contract as an unsatisfied condition subsequent.
Well, you'll have to develop this probably in greater detail in your written submission. But so I understand it. You're saying that the condition subsequent in regard to the amended construction contract was not satisfied because there were subsequent attempts to agree amendments, unsuccessful, but which were somehow anticipated.
It's more that all parties involved, so the claimant, Intermass, and the bank, were understood that price negotiations were continuing and amendment number 2 could not be relied upon as the final amended version of the construction contract.
Well, I've seen you show me a letter which rather makes good that point. I follow. No, just, yeah, okay.
It's common ground that the claimant's negotiation... before I move on, actually, let's just turn over the tab. And you did say, well, what does it matter if there was a further amendment in 2015? Well, there was.
Yes.
And it was only signed by Intermass, so this time not signed by...
Yeah, but the point for, in a sense, assessing compliance with the conditions subsequent is September 2014. At that stage, the bank had no idea, did it? Or, I don't know. There was a amendment number 4 in the arena.
No, the bank was just aware on the evidence before you that price negotiations were continuing. I think it's common ground between the parties that amendment number 2 was not provided by the deadline for conditions subsequent. 30th September 2014. It wasn't signed.
Well, it wasn't signed by either side until the 1st of October. It's not remotely clear to me when it was signed by the claimant. By the claimant, yes.
That's correct, Your Honour.
There's no evidence, I don't think, of when that signature was input on the document.
No, we can just assume it was after the 2nd of October based on that Hill International letter that I showed you.
That may be a fair assumption, yes. Thank you.
Okay,
I mean, that's good enough for you, isn't it? Or not? I don't quite know. I'm just sorry, I just need to have a feel why it's important to note that in January 2015, the amendment number 4 was in the arena.
Your Honour, if you're with me on...
No, I just want you to tell me why you're telling me it's important.
Well, if there's any argument about, as there is, on waiver, if there is any waiver, it can only be a temporary waiver or an indulgence to allow the claimant time
Okay, well then I'm beginning to understand. That's rather a different point. Yeah, okay.
I'll move on to the contractor's insurance assignment conditions.
Right, okay.
Now, again, Mr. Thomas said in his opening submissions on day one, we did not provide them, it's accepted with a document in that form, but what we did provide was that the contractor's all risks insurance was in the name of the bank. That's day one, page 77, lines.
We moved on from that, I think, but there we are.
Okay, I won't take up time on that then. I'll move on to the evidence that shows the conditions subsequent were not satisfied in form and substance that was satisfactory to the defendant. Now, all the outstanding conditions subsequent were referred to by the defendant in the 23rd February 2015 meeting between the claimant and the defendant. This is the controversial minute that we've seen a few times. I mean,
they're not actually specified, are they?
No. It says, to save us 10 minutes.
Anyway, you say the minutes is reliable. Okay, right.
Yes, and I just wanted to note that the accuracy of that record is now supported by the evidence of each of Ms. Shocker and Ms. Sokon that they gave yesterday. Yeah. If we could also have a look at Volume 2, and look at Ms. Shocker's second witness statement, please, which is tab 21.
Yeah.
And if we can go to paragraph 42, which is page 438 in the hearing bundle.
Yeah.
And you see the first sentence, Ms. Shocker is referring to the meeting on the 23rd of February.
So, paragraph which?
Sorry. Paragraph 42, the top paragraph. The first sentence, Ms. Shocker is referring to the meeting on the 23rd of February 2015. We don't need to repeat that. The second sentence reads, prior to that meeting, I had repeatedly said to Mr. Blow that the conditions subsequent in the restatement needed to be satisfied and that Mr. Al-Mahari's continuing failure to satisfy them would lead to NBAD halting further payments under the loan. In particular, I repeatedly told Mr. Blow and Mr. Al-Mahari that... I apologise, let me start again. In particular, I repeatedly told Mr. Blow that Mr. Al-Mahari needed to agree an amended construction contract with Intermas and provide NBAD with a copy as soon as possible. Now, the claimant has confirmed in his evidence yesterday that Mr. Blow was dealing with the day-to-day communications with the defendant on the conditions subsequent documents. Yesterday, the claimant also confirmed that he was not keeping track of what conditions subsequent were outstanding at any one stage.
I'm sorry to ask the same question again, but why was she wanting an agreement of an amended construction contract? What topic needed to be covered if there was no amendment?
Well, at this stage, this refers to the period before the February.
Well, this refers to the time when Amendment Number 4 was wandering around. Yes,
precisely. Where the bank is aware that there are these ongoing negotiations. There are these, based on Ms. Shocker's evidence, there are repeated discussions between her and Mr. Blow.
Yeah, but even if there wasn't a condition subsequent, presumably if there's a new amendment or substantive amendment to the construction contract, the bank must be given a copy.
Absolutely, that is
assigned to them.
Absolutely, and the assignment is also, of course, one of the conditions subsequent that we rely upon as being unsatisfied.
Yeah, but we've now moved on past September the 30th. Okay, yes. I mean, it would be a breach not to produce a copy. I don't think think it follows that it's a breach of the condition subsequent not to produce a copy in February 2015.
Well, if it's already a breach that the bank can rely upon as an event of default under clause 5.3, then yes. But if there's some indulgence or some temporary indulgence to allow the claimant and Intermas time to negotiate in order to finalise an amended construction contract, then we say that that evidence is relevant.
I understand.
So, of course, Mr. Blow would be the best person to have appeared before you to help you with what the claimant understood at the time of all these negotiations and incomplete proposed amendments going backwards and forwards. The claimant confirmed yesterday in his evidence that he did not ask Mr. Blow to appear as a witness in these proceedings. The reference for the transcript is day 2, page 12, lines 4 to 6. Now, we have the defendant's letters following the 23 February 2015 meeting, which expressly reserve all of the rights of the defendant in respect of events of default generally. They don't specifically identify conditions subsequent. There is an internal document which I'll take you to, and sorry, those letters went from 18 March 2015 up to 22nd April 2015. If I can ask you to pick up volume 12, I want to take you to an internal NBAD document which shows their understanding of where things stood in respect to the conditions subsequent. Tab 220.
Yeah.
The front page shows Mr. Sokon's email to Mr. Abdelhak, dated 20 April 2015. The first line makes clear what the document attached is. It's the status of conditions precedent and conditions subsequent for DAS. And it also says assignment is pending for both original and restated contract, and that's a reference to the construction contract. If we turn over to page 2715, see this is NBAD's internal document, which is a snapshot of their understanding at the time as to whether or not conditions subsequent had been satisfied. The first one is the copy of the construction contract amendment duly executed by all parties. The due date, of course, is 30 September 2014. In the status, it says pending finalisation of ongoing negotiations between the borrower and the contractor to determine the amount of the extensions of time and variations. Below, we have number 2, a duly executed original of the assignment of the construction contract, existing and or new enhanced contract. Again, the same due date, and then in the status column, pending. There's a reference to the old construction contract, but also reference to the new amended construction contract that's being negotiated. It says assignment of the new enhanced construction contract is pending finalisation of the same. And then down at 5, we have the reference to the contractor's insurances assignment, and again, it says pending in the status column.
Yeah.
Turn on to tab 227. Now, this is the defendant's letter dated 30 April 2015. It's the last tab in the
Yeah.
And this is the defendant's letter to the claimant dated 30 April 2015. And if we look at the third paragraph up, you see there is now a specific reference to conditions subsequent. It lists the conditions subsequent in 1, 2 and 4 of Schedule 2. So those are the ones that we're relying upon in these proceedings. So we say this makes clear that whatever has been provided to date to the defendant is clearly not in a form and substance that is satisfactory to the defendant. So we say, for conditions subsequent 1, 2 and 4 in Schedule 2 of the restatement, the claimant did not provide the documents that were required as conditions subsequent by the time they were due, 30 September 2014, or at all. And we say, as a result, the express contractual consequences should follow. They were events of default, and the defendant was entitled to exercise its contractual rights accordingly. I will deal with the claimant's arguments on waiver and unlawful exercise of rights in the written closings.
Well, you've been dealing to some extent with waiver, haven't you? You're saying that, well, if there was a right of termination, as at the 30th of September, as a result of breach of the conditions precedent, there was no, well, perhaps there was an affirmation. I'm not sure what the right expression would be. Yes.
Another reason for skipping over is because the evidence is obviously...
I need some help in sorting out the legal implications of all that. Thank you very much.
I'll address very briefly lack of good faith.
Yes.
Their argument under Article 246.
Yes.
Now, as we understand it, the claimant's argument appears to be that the defendant was obliged to give notice to remedy before relying upon the unsatisfied conditions subsequent. I have 3 points on this. The claimant has already correctly conceded that no notice to remedy is required for the conditions subsequent. There's no grace period, and that's expressly set out in 5.3b. If any notice was required, we say the contemporaneous documents and the evidence of Ms. Shocker in her second witness statement show that the defendant did more than enough to satisfy any such obligation to put the claimant on notice. The third point is it's difficult to see what difference any formal notice to remedy would have made at any time. I'll move on to material adverse change.
Yes.
The first question is, can the defendant rely upon the material adverse change event of default in circumstances where it did not specifically identify this event of default in its notice of demand dated 21 May 2015? Now, I wonder if we could pick up volume 6, Your Honour.
Yeah.
This is the restatement, and if we could turn to clause 23.13, which is the acceleration provision,
Yeah.
page 1119. The acceleration provision does not require the defendant to notify the claimant that it is relying upon any specific event of default prior to or at the time the defendant is exercising its rights under this provision.
Yeah.
It says, on and at any time after the occurrence of an event of default, the lender may and shall, if so directed by the lender, by notice to the borrower, and then the consequences, cancelling the available commitments, and then accelerating the disbursed sums for payment plus interest. Now, the material adverse change provision is just above, clause 23.11, and once again, there's no requirement in this clause for the defendant to notify the claimant of a material adverse change event of default. And of course, there's no remedy period provided in either of these clauses. It's stated, and it's clear from the notice of demand that was issued on 21 May 2015, that the notice of demand did not limit the events of default that the defendant relied upon. The defendant referred to events of default as ongoing defaults, including without limitation, and then identified the ones which we focused on. But it did not exclude any reliance upon material adverse change. In fact, the notice of demand expressly reserved any right or remedy that the defendant may have, and it included wording which made clear that nothing in the letter shall be or be construed as a waiver or otherwise prejudice in any way any other rights or remedies which the lender may have, all of which are reserved. So if we're right that the defendant is not precluded from reliance upon a material adverse change event of default, then the next question is two parts. Did the defendant believe that the claimant's ability to perform material obligations was materially impaired as at the date of the notice of demand? And secondly, was that belief reasonable? Of course, Mr. Thomas today has raised an objection to our pleaded case. This is the first time that this objection has been raised. We say our pleading is sufficiently clear. There was no issue raised when the claimant submitted its amended reply to those amendment provisions. In any event, for the purposes of this preliminary hearing, we've agreed issues. And in respect of the material adverse change issue, the specific issue we've agreed that should be determined in these proceedings is, was the defendant's notice dated 21 May 2015 a valid and lawful exercise of its rights under clause 23.113 of the facility agreement? A, was there an event of default under clause 23 of the facility agreement as a result of 2, a material adverse change pursuant to clause 23.11 of the facility agreement? And at B, you have the claimant's position in response to that argument by reference to their pleadings. Now, I don't want to get bogged down in a technical pleading objection in this closing submission. I would like to focus on the substance of the case. Now, Mr. Thomas said that there is no evidence from NBAD which says what their opinion was as at the date of the notice of demand. If I can ask you to pick up volume 2, turn to tab 17, looking at Mr. Sokon's second witness statement, and if we can go to paragraph 50. Page 363. Paragraph 50 you can read yourself, Your Honour, but I'd like to draw particular attention to the last sentence in that paragraph, which says, by 21 May 2015, I and my colleagues in NBAD's risk department and NBAD's legal department were concerned that Mr. Al-Mahari would not be able to complete the project at all and that he would default on his obligations to repay the loan. So this is clearly evidence from Mr. Sokon of what he and others at the bank thought as at 21 May 2015 when the notice of demand was issued. And we say that's entirely consistent with the contemporaneous evidence, which I'd like to take you to. And let's pick up volume 13, please. If we can go to tab 234. Mr. Sokon's internal email dated 7 May 2015, and we say it's an important contemporaneous record of what was of concern to the bank at the time. And it's also evidence of the formation of opinions within the bank at that time. Fourth paragraph down, in this email he says, there is no progress on site or any alternative arrangements so far from the claimant to resolve. I learned that he has approached several contractors with no success. Then skipping the next paragraph, onto the one beginning of the total cost, he reports that the costs are likely to increase well beyond 669 million, which of course is the full amount of the loan under the restatement. It says the total cost to completion will probably increase to 800 million to which will be added around 150 million in finance costs due to the ongoing delays. Now, Mr. Sokon gave further explanation of what this means in his evidence yesterday. In terms, Mr. Sokon said that the defendant was concerned that the level of debt that was now needed to complete the project was beyond what could be serviced by the estimated income from the completed project. From the transcript, day 2, page 173, lines 4 to 25, I'll read this out. This is where our main concern was from a financial perspective. It didn't seem feasible anymore to add more financing to this project because simply of the fact that even if it's completed in terms of construction, the income which will be produced will not be sufficient to deal with the burden of debt itself.
Thank you.
And if we can pick up volume 2 again, please. And if we can turn to tab 15. Mr. Sokon's first witness statement. If we can turn to page 320 in the bundle references, paragraph 45. See, Mr. Sokon here says, I explained to the claimant at the meeting held on 9 December 2015, some way after the notice of demand was issued, and he goes on to say that the cash flow for the development would not support additional debt finance from NBAD. This was evident from the low debt service coverage ratio, which would fall below 1 in the first 2 years of providing such additional finance, and which would significantly increase the credit risk for NBAD. Moreover, the claimant did not provide any indication during the meeting of any source of equity or other sources by which any shortfall in cash flow could be covered. So that explains, or that's entirely consistent with what Mr. Sokon says in his 7 May 2015 email, where he gives his view on the next step for the bank to protect its interests. To save you turning it up, I will read it out for the transcript. He says, legal action seems to be the best available option so far to protect the bank's interests, or at least to put pressure. I propose to start preparing with the legal department the necessary documents.
Thank you.
So we submit, Your Honour, that there is sufficient evidence before the court to establish that the defendant did believe that the claimant's ability to perform material obligations was materially impaired as at the date of the notice of demand. Against the background of the deterioration in the status of the project from January 2015, which I think appears to be accepted by the claimant, we also submit that the defendant's belief that there was a material adverse effect was reasonable. So on the basis of those submissions, as at the date of the notice of demand, we say there was an event of default as a result of a material adverse change pursuant to clause 23.11 of the statement. Right, that's all I have, unless I can assist you further.
Just give me 1 second, will you? Just help me with the phrase material. I'm looking at the definition of material adverse effect. It's a strange use of the word effect, isn't it? Obviously, one can identify something which materially impairs the ability of the borrower to perform. But it doesn't help to be told material adverse effect means material adverse effect. What does it mean?
Well, I mean,
usually one would expect material adverse effect is covering some event or step or position that adopted by the borrower, which has a materially adverse effect on his ability to repay. That's not what it says. It says material adverse effect means material adverse effect, i.e., what has gone wrong is what has gone wrong. I'm having difficulty with that, but maybe you can't help me. Can we just go back to the bizarre, the difficult clause 23.2? How would one formulate this clause to cover the position which I understand you to maintain, that a failure to comply with an obligation other than some level of, I don't know what 2334 is, the 22, therefore, sorry. Becoming a FFI or a tax obliger, forget about that. Under the finance documents, and such non-compliance is capable of remedy and is not remedied. Now you, I understand, say that as a matter of construction, nor do I think you say, in order to avoid what you say is the, I think you say, absurd result, that a failure to complete the project in time is not a obligation under which any event of default can arise. I think that's what you're saying. So it follows, you say, as a matter of construction, that something's gone wrong with this clause, and what it would mean to a reasonable businessman is that a failure to comply with an obligation is an event of default, except if the non-compliance is capable of remedy, then he's given a period of a sort of locus penitentiae. Is that what you say it means?
Precisely, that's our interpretation of the clause.
So in order to, the draftsman ought to have said, does not comply with the other obligations under the financial, save that, where such non-compliance is capable of remedy, it remains unremedied within 15 days of receiving notice to put it right. Yeah. Okay, thank you. Yes, well, thank you both very much indeed. Yes, Mr. Thomas.
Well, not much.
Don't forget, you've got plenty more to come.
I know. I mean, if you'd just rather not have.
No, well,
I was just going to make.
I'll give you 5 minutes.
Plenty. 2 or 3 points of clarification. The first one was the document that was referred to in bundle 10 at page 2258.
Yeah.
My 5 minutes trying to find bundle 10. It was the new, rather odd document.
Nearly there, hang on. Two, 258.
2258.
Yep.
Then it's slightly odd advice of Hill International. I'm not sure what's being said now. I think it may be, well, there's an advice from a project manager that I think it's being said, oh, well, you can sign this amendment, but that doesn't matter because there might be some further changes. Well, of course there would, or there might be. But if you sign the fact is, if you sign a contract amendment, you have agreed in a legally binding way.
I haven't actually read contract amendment number 2, but does it impose some obligation in regard to paying the full amount to Intermass?
Well, it changes the contract price. So
what seems to be said here, although it's of course not the contracting party who's speaking, that although the contract's been signed, it doesn't mean what it says.
Well, I mean, this is advice of a project manager. It's not actually relevant.
Yeah, but it's written the day after the signature, isn't it? Isn't it? Yes, it is. Yeah, day after the first signature.
The first signature. Yes,
and we don't know when the other signature was put on. So presumably in response to this letter, so this is addressed to DAS.
Yes.
So DAS signed after receiving this letter.
Yes, that's right.
Right. Okay.
I mean, so what we can say for sure is that it was signed between the 2nd of October and the 14th of November. We know it had been signed by the 14th of November because that's when we can see Ms. Shocker sending it to EC House.
Oh yeah, well done. Yeah, thank you.
So it's between those dates it was signed.
Right. Thank you.
The amendment itself is on the page 2263.
Yes. It's just an amendment to revise the contract price.
Yes. So, I mean, all it's doing is taking the original contract and
increasing the figure,
plugging a new figure into the price is. So that's a binding agreement that's the contract price, and the fact is that happens sometime in October or early November,
right?
And they get it when it's done. Okay, so they had the unamended contract until it was amended. When it was amended, they got it. Now they seem to be complaining that they didn't get some further amendments that weren't made. It's a very odd submission. If it were right, it would mean that the obligation could never be complied with because the contract might always be amended. So that was that one. Next was the reliance on Ms. Schrocker, paragraph 42, which, if you remember, is the general statement, I told Mr. Bloff that it was important that you get all the conditions subsequent through. Now, there are these general statements, just like, as your Lordship picked up, the general statement, assuming it was made on the 23rd of February. Well, general statements, we say, aren't good enough for the defendant. There are 3 specific conditions subsequent relied upon. The fact is that the whole condition subsequent provision did go on. I mean, if it goes on right into April, indeed it goes on into May. But for example, there is provision on the 6th of April, 12.218. They're dealing with the other conditions subsequent. I think assignments of the SPA contractor and so on. More peripheral things, but they're still being dealt with, and there's no complaint about those being late. But the point is that there are other conditions subsequent being dealt with. So general statements, you need to get your conditions subsequent done, don't really help. The fact is, the first time they identified these 3 as being outstanding is the 30th of April. And you have my submission on the contract amendment. They get it when it's made. The other 2, it's in their hands to provide the drafts, and they never do.
Clarify, Ms. Schocker's witness statement, paragraph 42, does mention a specific condition subsequent. It's not a general statement. It refers to the amended construction contract. Just want to clarify.
That's a fair comment. It mentions that one, but none other. And that one they just plainly had.
Right.
And then Finally, I was just going to mention the evidence that's referred to in relation to material adverse effect. Really, nothing could support our point better. What you've been referred to is one sentence of one witness statement saying that what one witness thought in May 2015, that's not evidence of the bank forming a reasonable opinion. Mr. Schocken played a part in what the bank was doing, certainly in March, April, May 2015, but he wasn't the decision maker. He doesn't say that he formed an opinion. He doesn't say whether he's addressed whether it's reasonable or not. The document that's referred to, Mr. Schocken's document at 13234, his email of the 7th of May, that indicates that the bank is going to start legal action to put pressure on. That's an indication of proceeding with the project, putting pressure on DAS to not terminate the contractor, but proceed. That's not a document that can be said to be the bank addressing its mind to whether there's a material adverse effect that entitles it to terminate because it's formed a reasonable opinion. Quite the contrary. And then, what on earth the relevance is of Mr. Schocken's statement about at the 9th of December 2015 escapes us. The bank must set out a case on reasonable opinion as at 21st of May. So if they're driven to rely on documents or evidence of the 9th of December 2015, it really just shows the lack of evidence that there is of there being a reasonable opinion.
Well, thank you all very much for your help, for your skeletons and your oral arguments. It'll take time to think about this. I must regret to report to you that my pending tray is awful, but I will do the best I can. Now, can I try and sort out the documents a bit? Can I remind you again that I want a chronology of cross-reference to the bundles? I'll receive that, no doubt, in due course.
That's in hand, and I think all that's done.
Thank you very much. Now, there are various bundles I haven't even touched, let alone opened. Can I just make sure I can leave them behind with impunity? Bundle 4.
Yes, Sir
Bundle
President.
5.
Yes.
Very disappointingly, I haven't been taken to the correspondence bundles, and I'm intending to leave all of them behind, unless you say I shouldn't. I assume by correspondence you mean correspondence between the solicitors, do you?
Yes, it does.
There's never much joy in reading them. And I'm not remotely surprised we haven't opened them. So there are no less than 7 bundles of solicitors' correspondence, which is, if I may respectfully say so, even worse than usual. So I'm going to leave those all behind.
I think essentially what you want is 1, 2, and 6 to 15.
Yeah, I'm going to take 1 and 2, of course, and I don't think I need 3, do I?
No, I think it's 6 to 15 then.
And then I'm taking 6 through 15, which I will take. Can I just find a home for this extract from Whelan that somebody gave me? Will you tell me where to put that?
That should go in the...
Must go in the authorities bundle, I assume.
Yes.
There's a transcript bundle, isn't there? Yes, good, thank you. I'm leaving the core bundles behind.
Yes.
I don't feel unhappy about that. What shall I have done with the authorities bundle? That seems to have done a runner. Hang on. Must be here somewhere, but I'll find it. I certainly need it. Although we didn't look at much of it, did we? That seems to be missing. Well, I'll find it, no doubt. Thank you. Right, well, I will sort myself out.
We need to just trouble your lordship on...
Oh, no, sorry, now written submissions,
Yes,
I'm sorry, I forgot about that.
Exactly.
Have you got any ideas?
Well, we've got two different ideas. They're a little bit different, and
Right.
I think if we just ventilate each idea, we had thought of asking for 10 days to do our written submissions. Mr. Francis and Mr. I think one rather longer.
Right. And what are you contemplating? An exchange or a
Yes,
sequential?
we were contemplating exchange, given we've had oral.
And a right of response?
And a right of response, yes.
Okay.
And we were going to tentatively suggest page limits, subject to your lordship's view.
Well, I won't hesitate in doing that. How many pages do you think you want?
We were of one view that the initial submission should be limited to 50 pages.
Yeah, I think so. That's fair enough. And
then,
the reply to 10.
We would happily agree that. I think.
Well, I'll chew the cud and hear what your opponents say. Now, that's on the basis of kick off 10 days, followed by another 10 days after that.
Well, we were going to say 10 days and then a week for reply, but there's
let's see what the other view is. Thank you.
Your Honour, unfortunately, on our side, we have holidays booked.
Right.
Which mean,
So what do you want?
we'd like 4 weeks in order to exchange.
4 weeks for the first round, effectively. Yeah, okay. And after another week for the second round.
That will be fine, Your Honour.
Sorry?
Yes, sir.
Well, I'm conscious that people like to write down something or other, still remember what the case is about. But the fact that you're waiting a bit doesn't mean you can't, what I call, get yourself ready. So I would accede to that application. So we'll have the first round in 4 weeks, followed by a second round 1 week later. Okay?
Yes.
Thank you very much indeed. If those could be sent. Now, can I invite you not to do, which I'm afraid has become a bane of my life, to start your final submissions? We incorporate into this final submission everything that we put in our earlier submissions. If you do that, I shall tear it up. So, will you please make a complete submission, although you're restricted to 50 pages. I'm simply not prepared to go back and forth between the various submissions. I hope that's not too wearisome. If that means you need another 10 pages, I would rather have that. Okay? So if you exceed, go to 60. I won't go mad. Is there anything else? No, I think that's everything. Thank you very much.
All rise.
I'm speaking to Oswald. Sorry.
No, I need to